Okay, everybody, we are live on YouTube. Representative Cords, do you want to lead off the discussion?
Sure, thank you, Damien. So the first meeting of 2021 for the House Discrimination Prevention panel is now underway, and the first order of business is to elect or select a chair. And I don't know if someone would like to start with a discussion about that. Kelly, do you want to talk about what's involved as the past chair?
Getting everyone to agree to a meeting time and making sure that it gets scheduled and being there to run it and walk us through the meeting. That's in a nutshell. I'm happy to nominate Mari Cordes for chair this year.
And I'm happy to second that.
Any other nominations? Well, let's vote.
Do you want me to do the vote since you're the...
Yes, that would be great. Thank you.
Okay. So why don't I just call everyone by name and you can give your vote. So Kelly.
Yes.
Taylor.
Yes.
Chris.
Yes.
And Mary Beth Redmond. Yes. Great. Did we lose someone on our... Oh, we did. Okay.
Mike logged off.
Yeah.
Okay, great. Good. So Mari, you are officially our chair with a vote of 5-0.
I'll say okay, and that'll be my vote. Thank you.
Oh,
all
great. Right. I didn't ask you. Sorry about that.
That's all right.
Okay, so unanimous vote.
All right. And do we have, I don't think, we didn't even take notes last time, did we, Kelly? I think we each individually took notes.
Right.
Okay, we'll just leave it at that. All right, Damien, the next, Damien did an excellent job going over this over and over again with us. And here we are again. Please go over it with us.
Sure. For those of you who don't know me, I'm Damian Leonard from the Legislative Counsel Office. I am the legislature's employment attorney. So this is a policy we worked on for a long time last biennium, and finally got it to the point where it was adopted last biennium. I did look it over the other night, and there are some things that need to be updated in here with the legislative staff restructuring. Some of the terms need to change. I even caught a couple of typos that we somehow missed in our 20 or 25 iterations of this bill last biennium. There are a few things that'll change. So I'm going to share it on my screen here, and I'll try to take you through it fairly quickly. I know it's Friday afternoon and you guys have all had a very long week. And we'll just do a quick overview. If you have questions, feel free to interrupt. And then the next time we meet, I can have an updated policy with the names changed and the dates updated. And then this panel is going to need to adopt it. And then let the speaker know that you've adopted it. And then historically, at least once the House has voted a resolution to adopt the policy or to recognize the adoption. I'm not good with parliamentary procedure, so I don't know if that actually happened last year with either the sexual harassment or discrimination policies.
Right. We were remembering that we had finally gotten to a place where we had voted on it and let the speaker know that, and then COVID happened and we were out of the building, and it just, fell to the bottom of the pile. So I don't believe that happened last year, but I think it was just because the world changed.
Yeah, that's an understatement.
Yeah.
So let me go ahead and
didn't
share
it?
my screen. And here we go. Okay, so let me take you through this. So this, as you can see, it's the 2019-2020 policy. So the opening 3 paragraphs here are a statement of just the general intent. So the House prohibits discrimination and retaliation for reporting discrimination or cooperating with an investigation of it. And it describes the creation of this panel in House Rule 90A and describes the panel's duty, which is to investigate and adjudicate complaints in a manner that's fair, expeditious, and nonpartisan. And then it states that the policy has been adopted by the panel, which would happen the next time we meet, and will serve as the policy for the House. And then it regulates and sets standards concerning the conduct of representatives and staff who work for the House, including an outdated list of legislative offices that I will update. And then it's intended to protect legislators, staff, pages, interns, members of the public, which includes lobbyists, advocates, press, and others in the building who experience discrimination that's attributed to either representatives or staff who are working in the House. So you'll notice that the Senate is excluded, and that's because the House has no authority over the Senate to regulate their behavior. The Senate has a sexual harassment panel, but not a discrimination panel. So if we ever have an instance where something comes up where a complaint is filed with this panel that relates to the Senate, we can wade through how that would be addressed at that point. But it would probably require a referral from this panel to, for example, the Senate Rules Committee to address it. So the next portion of this defines the prohibited behavior. So it begins by saying discrimination in the workplace is illegal and all employers have an obligation to ensure a workplace free from discrimination. Discrimination is unfair and unequal treatment based on a protected characteristic, which we will define later. And it includes conduct that limits, segregates, or classifies an individual based on that characteristic in a manner that would deprive or tend to deprive them of opportunities related to their work in the State House, or that would otherwise adversely affect the individual's status in relation to their work in the State House. And it also includes workplace harassment, which we define later. The protected characteristics under the policy are an individual's race, color, religion, national origin, sex, sexual orientation, gender identity, ancestry, place of birth, age, crime victim status, or physical or mental condition. And this mirrors the Vermont Fair Employment Practices Act, which is one of our 2 broadest discrimination protections in the state, along with the public accommodations law. And so I think this is the broadest wording of protected characteristics that we have in our law. It's worth noting nothing prevents the House from adopting a policy that goes even more broad than that. So that's something that the panel can always consider at some point, is whether there's a characteristic that is not listed here that should be. It then goes on to define workplace harassment, which is a form of discrimination, and it means unwelcome conduct related to or directed at an individual on the basis of a protected characteristic. It can include verbal, physical, auditory, visual conduct, or any combination of that. It can be subtle or overt. And it includes conduct that is not only unwelcome, but also conduct that could be personally offensive, fail to respect the rights of others, lower morale, interfere with work effectiveness, or violate a person's sense of well-being. So this is a fairly broad definition of workplace harassment. And workplace harassment is limited in that it does not include petty slights, minor annoyances, or disappointments that an individual may encounter during their time in the State House. So what's the difference here? The difference here is behavior that would be harassing, which could include the use of slurs, offensive pictures on someone's laptop, offensive jokes, offensive email messages, etc. What is not covered could be something like a committee assignment that a representative is disappointed in, someone losing their temper on an isolated basis in committee, or some sort of work disagreement like that, provided it doesn't cross over into overtly discriminatory behavior. So the difference here is someone getting short with me while I'm giving an overview of a bill versus someone saying something derogatory related to, for example, my religion or my ethnic background or something like that. So going on with that, it can occur in situations not only where there's a differential in authority, but also where individuals are equals, or where there may be an appearance of authority. And it can also occur where someone has less authority than someone else. So there are a wide variety here. It does not matter if you are the person who appears to have higher authority or lower authority. You can be either the perpetrator or the victim in both cases. And the other thing to note is the victim does not have to be the person toward whom the offensive conduct is directed, but could be anyone affected by it. So the example here is where someone says something derogatory to someone in the room, or in our case, the Zoom room, and the person who it's said toward kind of brushes it off, but someone else in the room who may share that characteristic feels personally offended and hurt by that behavior. That they could be someone who can say, that's behavior that I don't want to experience and I want it to stop. So we then go through a list of examples here. I think the list is fairly self-explanatory. Have all of you had a chance to look at this point? I'm seeing heads nodding, so I won't go through the list here just in the interests of time. The important thing to note is it just covers both behavior in the State House or virtual State House, as well as off-duty conduct that could affect the legislative work environment. So what happens when someone experiences harassment or discriminatory behavior? The folks have three sort of options within the policy, as well as options outside of the policy. The first is just to identify the objectionable conduct to the individual who perpetrated it and to ask them to stop. The second is to informally contact a member of the panel to seek some sort of informal resolution. So oftentimes folks may feel uncomfortable confronting a person directly, but they also don't want a formal procedure. They want someone to know that the behavior made them uncomfortable, made them feel discriminated against, was personally offensive, and they just want it to stop. They don't want any punishments or anything like that. And then the final option is a written complaint. And this should say to the panel, not the appropriate panel. That's a vestige from the sexual harassment policy that we base this on. And this would commence a formal panel process, which we'll talk about in a minute. And then another thing that this panel added last biennium is the option for folks to obtain information about the policy and options for resolution from a House member who's serving as a facilitator. And this is someone who's not a member of the panel, who doesn't have authority to enforce any sort of discipline, but is knowledgeable about the policy and can give folks sort of a discussion of what their options for resolution might be. So on staff, we have 2 facilitators, myself and Katie McGlynn. And what we do for other staff is if they've experienced something, they are allowed to come to us. It's completely confidential. And what we do is we help them work through their options. And that can be everything from talking about whether or not that behavior was a violation of the policy or just unpleasant behavior. And then if it was a violation of the policy, what are some of their options? And we might help them think about how to file a complaint. We might also just help them practice how they're going to talk to the individual who performed the behavior in the past. So it could be a wide variety of things. This is something you'll want to consider whether you keep it in here. And if you do keep it, who would you choose to be facilitators or approach about being a facilitator? So the other thing to note here that this notes is that there are also options outside of this policy. That's something we emphasize in a few places so that folks don't feel like they're limited. In some instances, you may feel like if I've been harassed by a member of the House, I don't feel comfortable going to a panel comprised of House members to resolve the issue. And so this gives folks other information about other avenues they can pursue. The only exception here is that for anyone who is or appears to be under 18 years of age, anytime that discrimination is witnessed or sexual harassment under the sexual harassment policy, it needs to be immediately reported to the Chief of the Capitol Police and the Sergeant at Arms. Because of their status as a minor, there are concerns about the behavior and concerns about whether, for example, it's an intern who's under 18, whether we need to contact their parent or guardian. Okay, so identifying the objectionable conduct. This policy basically states that the person who believes they've been discriminated against, their supervisor, if in consultation with that individual, or a person who witnessed the conduct, can all identify that conduct to the individual who engaged in it and ask them to stop that behavior. Are there questions at this point? Okay, not seeing any. The next is the informal panel process. And this allows a complainant, who's someone who's experienced the discriminatory behavior. I'm sorry, was there a question? Oh, no. Background noise. And then a supervisor or a witness can informally discuss an incident or conduct with any member of the panel without initiating a formal panel process. This is important because the panel has kind of a dual role here. One is kind of mediating these disputes informally, and the other is formally adjudicating whether a violation occurred. So the informal process is something that can be used both for something that's clearly a violation of the policy and something that may border on a violation of the policy, maybe in a gray area. So an example of this might be an isolated incident where the behavior was something that could be part of a harassment claim, and basically having allowing this individual who either witnessed it or is the complainant or the complainant's supervisor to approach the panel. And then the options here are, if the potential complainant gives permission, the panel can then attempt to resolve the situation informally, which would involve 2 or more panel members meeting with the individual who engaged in the behavior and identifying that behavior and asking them to basically stop the behavior. And this does require the panel to create a brief record of the incident or conduct, the resolution, and any additional actions taken. It is a confidential record. The reason why we need to create the record is because if there is a discrimination complaint filed in the future, we, as an institution, need to be able to show that when we became aware of the behavior, we took immediate corrective action to try to get it to stop. And that's important from a legal liability standpoint. And it's also important for creating a safe working environment for everyone. Rather than saying, I'm going to wait till someone files a formal complaint, you're heading things off before they get to a point that's potentially where potentially really egregious behavior occurs, or where something has been allowed to go on for so long that numerous people have been harmed by the behavior. And then the notification here after the resolution, there would just be a notification to the speaker that there was an informal resolution, but it wouldn't identify the specific incident or conduct or the identities of the individuals involved. Another thing that can happen here is the potential complainant could decline an informal resolution, saying, I don't want the panel to go forward with something. There is a caveat here, and it gets back to this legal liability issue. We have an obligation under the law to take immediate or appropriate action to ensure that conduct that violates the policy does not continue. This is a very, very fact-specific calculation here, but if it looks like the behavior may repeat or continue and is not just an isolated incident, then the panel needs to still take action to make sure that the behavior doesn't repeat. And you need to inform the potential complainant of that obligation and basically say, and it's again going to be very fact specific. In some instances, what was complained of may be an isolated incident and there may be no need to take further action. In some instances, though, you may need to have a conversation with the individual who engaged in that conduct and explain that you're aware of the conduct and that it may constitute a violation of the policy and that it needs to stop going forward. Even though the panel is not taking any further action at this point, you're just aware of it and you're advising them that the behavior needs to stop. It could involve something beyond that in terms of, with staff, we sometimes have the option of moving staff around. There are other solutions that might be available. Like I said, it's going to be very fact specific, depending on what the behavior is and what the potential solutions to that behavior are. Another thing that can happen here is if as you're gathering information, it becomes at least initially clear that it appears there was a clear violation of the policy, the panel can initiate its own formal process to address that violation, even if the complainant, the victim, doesn't want to move forward. And this may be an instance where someone is afraid of retaliation, but the behavior was extremely egregious and needs to be dealt with. And again, this is very fact specific, and it would be something where the panel then votes that they're going to initiate a formal process without being requested by the individual who experienced behavior or a supervisor or someone like that to do that. The formal process is requested by the complainant or the victim of the behavior. Anytime a member of the panel receives a complaint, you've got to advise the other panel members that you've received the formal complaint. The complaint is not required to be in a specified format. It may be written by or on behalf of the complainant. Something that may happen here is a complainant comes to their supervisor. The supervisor records the details and then the complainant signs it and it gets submitted to the panel. Another thing that could happen would be that an employee comes to a facilitator or another member goes to one of the house facilitators and the facilitator helps draft the complaint and then the complainant signs it and submits it. And the complaints can be just like the sexual harassment policy about any currently serving member of the house or any current staff person, but it is not limited to the current biennium. So just to use me as an example, I've worked here for 7 years. So it could be about anything that happened in that 7-year period. Representative Small, I see you have a question.
I'm wondering if we need to amend this piece as we are working remotely, and wondering how folks would be able to sign a complaint, whether it would be an electronic signature or another version of submitting that.
Yeah, I think that might be something that, again, this was drafted before the Zoom era. So it may make sense to say that it can be signed or sent electronically by the complainant. Just to clarify that, I'll make a note to clarify that. And okay, so that is a very good point. If you do catch issues like that as we're going through it, please stop me, because I've got a working list of things that I need to search for in the document update. Other questions at this point? Okay. And please speak up. I can only see 3 of you on my little drop-down screen here, so I may not see your hand if you're waving at me. So the panel's procedures are: once you get a complaint, a copy is provided to the individual who's alleged to have engaged in the discriminatory conduct. That individual is requested to file a response within 7 business days, and then a copy of that is given to the individual who filed the complaint. The panel can extend the time for good cause. So, for example, say the respondent is about to leave on a trip, say they're unavailable, we're out of session and they're unavailable for whatever reason. You can always extend the time here as necessary for good cause, but the seven business days is the baseline. The panel may choose not to take any further action on the matter if there's a pending criminal proceeding that relates to the same allegation. So, for example, if someone is subject to a hate crimes investigation, that would also potentially, be a violation of the policy here. So you could choose to stay your proceedings while you wait for the criminal proceeding to run its course. Any panel member who is a complainant or a respondent is prohibited from participating in the proceedings related to that complaint for obvious reasons. If a panel member is a witness, they can be prohibited from participating as the panel deems appropriate. So this would be a case-by-case situation here, and the panel would need to make that decision. And then if the complaint doesn't contain any allegations of something that would constitute a violation of the policy, the panel would dismiss the complaint and notify the parties of that decision. And this does happen occasionally, where there is behavior alleged which is essentially bad behavior, but not discriminatory behavior. And this, I'm trying to think, in my experience here, and I can't talk about specifics, but this has happened before in some cases where folks file a complaint because they want someone to hear them because they've been hurt by behavior. Unfortunately, it doesn't fall within the panel's jurisdiction because it doesn't constitute discriminatory behavior, or on the other side, sexual harassment for the sexual harassment panel. If the complaint contains allegations that could constitute a violation of the sexual harassment policy, the panel would refer that to the appropriate sexual harassment panel, and then would identify the allegation that could constitute a violation of the sexual harassment policy, and then inform the complainant of their right to submit a complaint to that panel, and then of the names of the members of that panel. So, for example, if it's a complaint against someone who was working in the Senate, you might send it to the Senate, direct them to the Senate panel. Representative Cordes?
I'm wondering if here we also want to add that especially if the behavior is egregious, that we as a panel can refer the case to the panel for prevention of sexual harassment ourselves. That's
a good question for the committee to weigh in on. It's definitely something we could add. The balance here is whether you want to require, consent or consultation with the complainant. We could phrase it as, if it's egregious behavior, the panel can refer it on their own motion, sort of their own decision, or the panel can offer to refer the behavior to the appropriate panel on behalf of the complainant too. And that, for some instances, that may be something you want to consider. Sometimes the act of just filing the first complaint, especially if you've been undergoing ongoing discriminatory behavior, that can seem like such an enormous hurdle for the person filing the complaint, particularly if there's a perceived power differential or something like that, that the act of then having to go to a second panel is too much. So it's definitely something for you to consider, but we could draft it however the panel thinks is appropriate.
How about we put a placeholder in for that so that we can get through the rest of the document, and then a subsequent meeting we can talk about it, including that it should be in consultation with the complainant.
Okay, I'm just going to make a note here to put in placeholder language that the committee can consider. I'm sorry, the panel. Okay. The next thing that happens is a written request to the Office of Legislative Counsel and any other office of the General Assembly that may have relevant records for any prior records involving the complainant and the respondent, and any other records or information that may assist the panel in determining if there's a pattern of behavior here. So in some of these instances, there are a couple of different things that could happen here. One is we have a panel with completely new membership at some point in the future, and they need to request back and say, have any complaints been filed against Representative X in the past? And that would be legislative counsel, either myself or the attorney staffing the panel at that point in time, would look back through the panel records and say, yes, in 2022, there was a complaint filed and it was informally resolved, or yes, there have been 3 informal resolutions over the years, or maybe no, there have been no complaints in the past. There may also be, you may also have staff saying, I brought this to my supervisor first, they did the following, and so forth. So you may request that that supervisor provide you with any records they have relating to that. And then the next provision in here is that the panel would contract with an attorney or other independent individual or entity with expertise in the area of workplace discrimination and harassment, who we refer to as the investigator, to then investigate the allegations. And this is to basically provide an appearance of impartiality here, so that there's no appearance that the panel may have, not asked the hard questions because it was a member of, with a lot of authority or perceived authority within the House or something like that. And then we do have a list of investigators that we maintain and periodically update in consultation with the Human Rights Commission, just to basically have folks that we can call if something comes up. And then the panel would review the investigator's report and make a preliminary determination as to whether there was a violation of the policy committed, and then provide a copy of the report to the parties. If the preliminary determination is that there was no violation, the complaint would be closed and remain confidential. And then 2 or more panel members could meet with the complainant and the respondent, either separately or together, depending on the circumstances, and summarize the basis for the determination. A brief letter summarizing the panel's action, but without names or other identifying information, would be provided to both parties. And then the chair would notify the speaker that the complaint had been closed, but not of the incident or conduct at issue or the identities of the parties. Again, we're preserving confidentiality if there's no violation. If there's a preliminary determination that the respondent committed a violation, then the panel would meet with the respondent and complainant, again, either separately or together, and allow them to review the documents and evidence, and then inform those parties of why the panel came to that determination. And then at that point, the panel can do one of the following: issue a written warning to the respondent, and then provide the complainant with a brief letter summarizing the panel's action that sort of summarizes the basis for the decision, but doesn't have any names or identifying information. And then a notice to the speaker of the disposition, but again, without any specific references to the exact conduct or the identities of the parties. The panel could also do a mutually agreed to resolution, which is basically like a settlement where we found there was wrongdoing and the parties agree that this is how it's going to be resolved going forward. And then again, notice to the speaker, but without, again, identifying information for the parties or the particular incident. Or in the most serious situation, draft and present charges and set the matter for a hearing. And then you'd provide the parties with a copy of the charges. So essentially it's saying, based on the investigation, the panel believes there's preliminary basis to find that the following provisions were violated. And then the respondent has an opportunity to review the report and all related documents and evidence, and to file an answer. And then at that point, the chair informs the speaker of the incident or conduct at issue, that the panel has drafted charges and set the matter for hearing, but does not identify the parties. And then the parties can jointly agree to waive the hearing at any point in the process. This would be essentially like a guilty plea at that point to say, okay, I agree that I engaged in the behavior, etc. The hearings are presided over by the chair of the panel. Legislative counsel provides legal advice and assistance to the panel. The investigator's report is presented to the panel. The panel can contract with the investigator or another person to prosecute the charges. And then that person presents evidence, calls witnesses, and presents arguments to the panel. The complainant and respondent can each have an individual of their choosing present to provide support, or can hire their own counsel at their own expense. Counsel or any individual who's present to provide support cannot be a potential witness at the hearing. That's the one restriction there. And then the complainant or respondent can testify, and then the complainant and the respondent or their attorneys can present evidence, question witnesses, or present arguments to the panel. So essentially, the panel is given a chance to sort of make its case, or have its investigator make the case. And then the parties are given the opportunity to make their own cases there. And then the panel can conduct a single hearing with respect to multiple complaints that relate to either the same respondent or the same incident or series of incidents. So this could be one respondent who engaged in discriminatory behavior towards multiple people, or an incident in which there were numerous people involved and it's being consolidated for a single hearing. Hearings are closed to the public unless the parties agree that it can be open to the public. The panel is not bound by the Vermont Rules of Evidence and can admit any evidence that the panel considers to be reliable, material, and relevant. The chair makes evidentiary rulings, but those can be overruled by a majority of the panel. And the panel's decision cannot be based solely on hearsay evidence. Are there questions on that? We're starting to get into the legal weeds here. Okay.
I just want to check in with everybody, including you, Damien. It's a little before 4. Are you okay going a little bit past 4?
I can do that. And does that work for everyone else?
I actually have a 4 o'clock meeting I have to go to.
Okay.
So I can just drop off if you all want to continue.
How about everyone else?
I'm good for a little bit longer.
Yeah, I also have a 4, but I can be a little late to it if need be.
I wonder if this might be a good stopping point then, at the burden of proof. I think we spent quite a bit of time on this before, so it might be good if everyone gets a chance to review it, and then we can connect by email and find another meeting time and wrap it up and look at next steps.
Okay.
Can I ask a question?
Sure.
I just was curious, what happens if there's a discrimination claim or harassment toward one of us on the panel? What happens there?
So you would step into the role of complainant, and then you would be recused from hearing the claim, but you could file a complaint with the panel, and then just have to recuse yourself. So the panel would then investigate as normal or engage in an informal resolution. Got
it. Thank you.
Yep.
And we could have an initial confidential conversation with one of the identified facilitators in Ledge Council.
Yeah, I think for purposes going forward at this point, I'll be the Ledge Council staff person who staffs the committee unless I have a conflict. And the instance when that might arise is if someone has come to me as a facilitator. And so I've already advised them on this. I then can't staff the committee. And at that point, it would be one of my fellow attorneys at Ledge Council. Historically, it's been the chief counsel, Luke Martland, the two deputy chief counsels, Jen Carby and Mike O'Grady, and then Katie McLennan and myself. The House clerk used to be one of the Ledge Council attorneys who staffed these panels, but obviously in her new role, she has got different responsibilities now, and we miss her greatly. So, yeah, so currently those are the other attorneys. And then if we ran into a situation where for some reason more attorneys were conflicted, we would find an attorney within Ledge Council who could basically be walled off and provide legal counsel to the panel. But we should always be able to have an attorney available who can be walled off and provide legal counsel.
Thank you.
Great, thank you.
Sure. So what I will plan to do, since we're winding up now, is go through and update the policy for our next meeting with the sort of administrative changes around new names for legislative offices and dates and so forth. And then I will make the electronic document change and do the placeholder language for a referral and consultation with the complainant. And then beyond that, I won't make any other changes, and we can pick up where we left off at the next meeting. Does that work, Madam Chair?
That sounds good. And I will send out an email. If we could start maybe with you, Mary Beth, with some dates from you that seem to work. And we can build the agenda together. I think obviously we want to finish going through this policy and any changes that we want to make to it. But if any of you have things that you want to discuss, just send me an email or a text or whatever your preference is, and let me know and I'll add it to the agenda. And then I'll get that to Mike Ferrant.
Thank you for your willingness to flex around my schedule. I'm really grateful for that. The days of the week and the time frames that I gave you, Mari, are pretty universal week to week. So, you know, feel free to use that same list for a future time slot.
Okay. That's helpful. Thank you.
Sorry, I just realized we still had the document up. Now we can all see each other. Great. Well, if that's it, I will take us off of YouTube if you're ready to adjourn the meeting.